Oh, hello everyone, it's Susie, Crypto Granny here. Just want to talk about the Ripple lawsuit and the SEC, if you can make heads or tails out of it, and other news as of the 20th of December 2022. So I've got my disclaimer because I'm not a lawyer. So this is only education only. Nothing influenced from it, just things that I can glean from it and understand. And I had to look up a few law codes or words because I didn't quite understand what they were. So it's very confusing what's happening here with this lawsuit. But we'll have a talk about it and go through the slides, and I hope you can understand it. And also we'll talk about David Schwartz having a go at Buterin as well. The co-founder of Ethereum. So this came to the market about 9 hours ago, and it's like about 8 o'clock, 6 o'clock here in Europe, right? So just bear with me, I need a glass of water. So the Ripple lawsuit, another win for Ripple. Judge partly rejects SEC's request, okay? And here's the, if you want to look it up, here's the internet code that you can look up, the resource. And basically what it said is she issued, whoops, I went back. Sorry, how do I do that? Sorry, go back. Oh no, now I've done the wrong thing here. Go back to the first. Sorry about this. Here we go, playing with my system here. So what the judge said, Annalisa Torres, district judge, issued an order partially rejecting SEC's motion to redact several details. And redact is take it out, okay? That's my understanding of the word redact. It's a legal term as well. So Annalisa Torres, district judge, issued an order over the Daubert motions in the XRP lawsuit. The decree is regarding the parties' motion to seal documents in connection with the expert challenges. However, the verdict around summary judgment is still pending. As per the order, the US Securities and the SEC Commission was seeking a ruling to seal and redact certain documents deposited by the parties to exclude expert testimony. The Commission, in its request, mentioned that it proposed redactions aimed to protect the identity of expert witnesses. Now, in plain speak, and again, I'm not a lawyer, but in plain speak, this is my understanding of this. The SEC is relying on expert witnesses and testimonies, the Ripplenet, the Ripple system, the technology of the Ripple system, and it's looking at SRC to decide whether it's it's looking at XRP and saying, look, this is security, and it's relied on certain expert testimonies. But what they want to do, the SEC, is basically redact those documents, even though they're saying when they're relying on an expert testimony, but also giving the expert testimony anonymous, making them anonymous. So Ripple and the judge doesn't know, or the judge might, but Ripple themselves don't know who the expert testimonies are from the SEC, who they used in the SEC for these expert testimonies. Now, the Daubert Motion is a legal thing, and I'll try and explain it as good as I can. But it basically means, in normal speak, that we can all understand it, that certain motions that the expert testimonial person has to get over a certain amount of steps to make it a valid motion. So, for example, if this expert testimony, the SEC is saying is an expert on Ripplenet and Ripple system and XRP, then they're saying we should be able to use them, but the SEC at the same time is saying we want them to be anonymous. But under the Daubert motion, the expert person needs to have certain skills and understanding of the technology and all sorts of things. And there's all these different steps that you have to comply with to be an expert testimony, okay? So this was actually put in law, but it was also case law back in 1993. So there's two versions of law, case law and legal law, okay? So it was put into legal law as well after the case law of a fellow called Mr. Daubert, or however you pronounce his name, Daubert, okay? So I hope I can make this clear. So what happened, right? they're obviously seeking different parts of certain things to be shown to the public and certain parts of evidence to not be shown to the public, and also, you know, certain people to be anonymous to the public, okay? So basically, in certain states, they redact certain information to protect, say, Ripple's confidential business and interests and legitimately private interests of third parties, right? The defendants, which are basically Ripple's the plaintiff and the SEC, well, actually, no, sorry, the SEC are trying to sue Ripple, and Ripple are the defendants, okay? So the SEC is the plaintiff, right? Gosh, legal stuff. Okay, so the defendants asked the court to argue the revelation that details under directly result in major damage to their negotiation position in the future. So basically, Ripple's saying we don't want a lot of our private information leaked because it could give someone else a competitive advantage in the future with sales policies and pricing policies and everything, okay? So basically, the judge granted the notions of SEC and the motions. They ordered that the court denies the commissioner request to redact the names of the consulting firms which help its expert witness, while it grants the watchdog appeal to redact the documents deposited in the link with Daubert Motion. So what they've said is here, the SEC have said, look, we've relied on expert witnesses for the Ripplenet technology system and XRP, and we use consulting firm names, but we don't want their names being privy to the public. We don't want them put out in the public, okay? So the judge said basically, we'll take, you don't have to put aside, give the documents into public, but we're still going to release the names of the consultancy firms which you use as expert witnesses in the so-called Ripple technology. And you decided with those consulting firms, the SEC, Mr. SEC or Mrs. SEC, that essentially you've decided that XRP is a security, okay? So the judge basically said, no, that's not good enough. We will say you don't have to put all the information in, but we do want the, you know, we want the expert witnesses, and we want to know the consulting firms. And I think that's fair enough, okay? That's absolutely fair enough what the judge said, and I agree with her. Judge Nelisa Torres, okay? So what do we mean by this Daubert Motion thing, right? Now there's a whole, I've given a link here about what it is, a guide to it, but it's basically a specific type of motion in Lamine. Now Lamine, what was that? It was something to do with, you know, happening at the time. Raised, whoops, sorry, God, this is really hard, this, because I'm not a legal person. Raised before or during trial to exclude the testimony of an expert witness, okay? So once this Daubert motion is filed, the party seeking to admit the testimony bears the burden of proof and must prove by a preponderance of the evidence that the expert possesses the requested level of expertise and the testimony is based on reliable methodology. Now, they call it the Daubert Motion because of a case back in 1993, which became law. But what the judge is saying, you know, this is a motion that's been put in place. You, the SEC, Mr. SEC, you relied on all these expert witnesses from consulting firms, right? And you're saying you want them to be anonymous, but then we as the court and Ripple has the right to know exactly who these expert witnesses are, that your views with the consulting firms, right? And we as the court and Ripple and the judge need to make sure the expert witness has the requisite level of expertise and testimony based on reliable methodologies. So what did the SEC use in their methodology to determine that Ripplenet, you know, is garbology of the system or technology of the system, and that XRP is a security, okay? What did they use? It's not a black box. The judge is asking, what methodology did they use? It's not a black box. You cannot rely on the anonymity, you know, of expert witnesses when it's fundamental to this case of Ripple, which is amazing, incredible technology, bigger than 1992, and yet you know, the SEC are trying to hide by all these rules and, you know, all these legal things, right? So the judge basically said, no, we need to know, you know, we need to know who these people are, right? So effectively, under the Daubert standard, the trial judge, which is Annalisa Torres, serves as a gatekeeper to determine whether an expert evidence is deemed reputable or relevant. Okay, so there's two tests here. The trial judge will employ a Daubert test to assess whether an expert witness's testimony is based on scientific valid reasoning or technology or cryptocurrency technology reasoning, and whether it had been applied properly to the facts at issue. Failure to comply with the Daubert standard can result in the exclusion of an expert's testimony. And that's where it's at the moment, right? There's no way the SEC can hide and say anonymous. We relied on consulting firms which are supposed to be experts, but we want to know who they are, right? Because cryptocurrency technology and certainly crypto is very new in the scheme of things. And most people in fiat financial markets and fiat legal systems haven't got a clue about the technology of cryptocurrency. And many cryptocurrency assets have very different technology, depending on the industry and the sector they're in, okay? Completely different technology. So we want to know what methodology, and so does the court, what was the methodology that the SEC used to decide that to decide that XRP was a security. Now, we know people at the time of the SEC in 2018, you know, William Hunter and that sort of thing, they were working and consulting for Ethereum, okay? So we know there was a huge conflict of interest here. They were getting paid. Two of the lawyers at the SEC were getting paid by the Ethereum community. Huge conflict of interest. And just so happens that they said, you know, Ethereum and Bitcoin are not securities, but they said XRP is, and they didn't come up with any methodology to why that is. And this is why the SEC is a black box, and there is no regulation, and they're not clear to anyone. And honestly, I think that is just unbelievable. You know, they're trying to find XRP billions, right, for allegedly selling securities without a product description disclosure to the retail market, you know, or, you know, basically like in the equity market, you need a prospectus that's got to be signed off by lawyers and auditors and everything, right? Now, the thing is, even Liberty, you know, they've been fined by the SEC $22 million for allegedly selling a security. And even they're going back to the SEC and saying, your fine are just obscene, fair income. Now, this year, I mentioned this age ago, the SEC has already made $6.4 billion in fines, mainly out of fining crypto companies, cryptocurrency companies, okay? Whether it's exchanges, whether it's a company trying like Ripple or Liberty, right? 6.4 billion. To put in context, you know, a year ago it was 3.5 billion, and a year before that it wasn't even $1 billion. So the SEC are targeting crypto companies because they can get away with it, if you want to call it that, and then making, you know, money hand over fist. It's become a profit center, the SEC, rather than what it should be, a cost center, and working for the people in the markets, right? In the markets. And that includes the cryptocurrency markets, okay? And also, we'll say the people in the SEC don't seem to have a clue just by what they say about the cryptocurrency technology. They never, ever talk about cryptocurrency technology. And we hear this in the government as well, people. US government, every time a senator says we have to close down cryptocurrency. Do they know anything about the technology? Do they know anything about the incredible payment system that XRP has, Ripplenet? They just don't know anything. These people are, you know, honestly, this is new technology, bigger than the internet that came in 1993. Get with it, the SEC. The people that are looking at this haven't got a clue. They never talk about the technology, which is incredible. Can change the world as we see it. Seriously, and I'm not kidding when I say that. Right, so the Daubert standard for expert testimony. Now, I told you, it was a case back in 1993, I should say. Get my 90s and 20s mixed up, so many numbers going through my head, people. And it was this case, right? And I'm not going to go too much on that. If you're a legal buff, you can look at that, right? But what it said is, right, whether the theory or technique as questioned can be used and can it be tested? How did the SEC test Ripplenet system? How did they test XRP? What methodology did they do? Whether it been subjected to peer review and publication? No, the SEC didn't put it out in the market for peer review and publication. They just made a decision that XRP is a security, right? But Bitcoin and Ethereum are not. I mean, give me a break here. You know, it's a conflict of massive interest when someone's making a decision about XRP, whether it's a security or not, and those lawyers of the SEC are sitting, you know, in the seat of Ethereum and getting paid with Ethereum. It's a conflict, a massive conflict of interest, total biasm in every way, right? Then the next test is it known or potential error rate? They wouldn't have a clue. You know, Ripplenet has done millions of ledger transactions, big ones. And imagine a ledger transaction, huge, one ledger of something, you know, 10,000 transactions. Well, they've done 70 million or 80 million ledger transactions since they've been in operation since 2012. And there's never been a hack and there's never been any errors or anything. The system keeps working. How many times you hear other cryptos go down or a hack or this or what? Also, the next standard is the existence and maintenance of standing controls in its operation. Again, nothing from the SEC. Whether it attracted widespread acceptance within a relevant scientific community, yes, we could say yes. You know, the 200 million people that use cryptocurrency, everyone knows about XRP. You know, XRP have millions and millions and millions and millions of clients, millions. And those clients use Ripple's technology. It's as simple as that. Right, let's go forward. So, you know, the SEC, you know, trying to say, hey, you know, we've got this expert, but we don't tell anyone. Well, the judge goes, you know what? You know, you're expert. Who is he? Is it junk science or what? You know, what's the criteria? How did the expert substantiate their testimony? How do they say that? So the judge, fair enough, under this, right, under this Daubert law, right, there's other requirements, right? And there's a rule called Rule 702. This is made legal. Rule 702 of the Federal Rules of Evidence makes no distinction between scientific knowledge and technical knowledge or other specialized knowledge, right? Technology, cryptocurrency technology, right? But the person is qualified as an expert should know and have all this training and education and, you know, knowledge of cryptocurrency market technology, right? And the education. So the expert opinion's testimony is listened to if the following conditions have been met. The expert science, technical or otherwise specialized knowledge will help the try of the fact to understand the evidence or determine the fact and issue. The testimony is based on sufficient fact or data, which is not. The testimony is the product of reliable principles, methods. We don't even know what they are because the SEC won't tell us. I mean, this is a joke, man. The expert has reliable applied the principles, methods. But we don't know that because we don't get told anything by the SEC, and they don't want to release that to the public to help us decide how they made that stupid decision that XRP is a security and Ripplenet's technology is not the most advanced thing we've ever seen since 1992. Fair income, you don't get any information from these guys, right? So, you know, again, these motions can come in a separate motion, a party of summary judgment, motion in line, you know, all this sort of stuff. I won't go too much into it. But, you know, the types of challenges, you know, within these motions, and rightly so, you know, the judge is saying, what's the expert's qualifications? Ripple's saying the same thing. What's the expert's qualifications? What's their methods? What's their science that they relied on? What is their methodology? And yet the SEC is silent on it. Seriously, it's just not good enough, right? It really isn't good enough. I just find it incredible. Okay. You know, so that's where it's at the moment, right? So what's this one? Okay, go forward. So it's a good, you know, and like this says, the best defense is a good offense and surviving, you know, this challenge. And I don't think the SEC will survive this challenge because they don't want to say how they got to that conclusion that XRP is a security. They're not showing the expert witness methodology or how they made that decision, or did they look at the technology? Did they go to peer groups? Did they talk to the community? No. I mean, this is the travesty of justice, people. It really is. It's a travesty of justice, right? So Judge Torres has issued an order to the parties to seal certain documents in connection to the expert challenges, but the SEC is on the hook to be able to explain how these expert witnesses decided with them that XRP was a security, right? And what methodology did they use, which doesn't exist, okay? Doesn't exist. So let's go to the next one. Now, another news story overnight was Ripple CTO David Schwartz has criticized Ethereum founder Vitalik Buterin for misrepresenting Ripple's native XRP. Mr. Schwartz slammed Buterin for failing to understand or pretending to be unaware of the distinction between Ripple and XRP. David Schwartz claims Vitalik pretends not to understand XRP. In an earlier podcast, Vitalik Buterin said XRP has not apologized, this is hilarious, for complaining that Bitcoin and Ethereum are controlled by the Chinese. Well, you know, I got news for you, babe. 3 years ago, they were Vitalik controlled by the Chinese. As you know, 75% of the miners controlled XRP and Ethereum. But since the Chinese government then closed down all mining, clearly we're now seeing more of the miners coming to the US or going to other countries where it's very cheap to mine because electricity and water is cheap, okay? So get over that, man, fair income. Anyway, Mr. Schwartz said, David Schwartz said, all this time he still doesn't understand or pretends not to understand that Ripple is a company and XRP is a digital asset. He believes XRP has the ability to say things. I think that's quite funny, actually. Very funny. So what else is here? Oh, here we go. And oh yeah, we got that. Yeah. So, you know, obviously Mr. Schwartz is saying, look, you know, this guy should know the difference between XRP and Ripple, and that's fair enough. And he always seems to be a bit of a hater of XRP, that's for sure. Now, where am I going with this? Okay, what else we got? Oh, here we go. Okay, that was that. Okay. Earlier this year, Ethereum founder infuriated the XRP community by claiming XRP lost its right to protection after Ripple attempted to throw Ethereum under the bus as China controlled. Well, technically, it was Chinese controlled a couple of years ago. You know, as I said, 75% of the miners were Chinese out of China, and no one could compete with them until the Chinese government closed it down and made it illegal. Buterin also claimed that XRP was completely centralized in the podcast. Centralization has been hot. He's completely wrong about that, right? Now, Ripple has over 1,000 nodes, okay, 1,000 validators, right? And there's different validators and different nodes. You know, you're either an admin authority or, you know, a high prime node or whatever you want to call it. But over 1,000, Ripple in the past only controlled 2 of them, and 2 of the nodes they control out of 1,000, which doesn't make it centralized, okay? I mean, he doesn't obviously know his maths. If it's centralized, then you know, Ripple has to control more than 51% of the nodes, okay, or the validators, right? You know, so they don't have any. They have 1,000 nodes or more, and they're building all the time. Now, again, Ripple actually reduced those dependent nodes, or the ones that they control, and they don't have any nodes anymore, okay, of their own. There may be one, but they still have 1,000 validators, which makes Ripple's technology decentralized. So certainly, David Schwartz is correct. Mr. Buterin is misrepresenting Ripple and XRP with a bit of FUD. And we have so much FUD out there because people that don't know Ripple and XRP are just a bunch of, what can I say? I'm going to be polite about it, guys and girls. You know, I just had a birthday. I've got to be polite about this. Fair income. But I've been nice about it. Okay, so let's go. Ripple dates very quickly. From what I can see, you know, everyone was getting decided. There was something happening on the 12th, whatever. Now, Mr. John Deaton says it could be delayed until April or May, at least March, because there's all these filings and ongoing cases and God knows what else. Documents after documents. Don't forget, the SEC has asked Ripple for hundreds of thousands of documents in the millions. This thing keeps going on and going on, okay? One of the attorneys resigned, Nicole Tatz, because she was leaving the office of the attorney's office and going somewhere else, okay? But the company still looks after Ripple, right? It was no big deal. She's just gone to another job, a higher paying job. Being a lawyer in America, you earn a fortune, right? You earn a friggin' fortune. I'd love to be a lawyer in America. Seriously, the lawyers are making a fortune out of this, right? A fortune. God knows what you got to pay. Fair income. We already know that Ripple paid over $100 million for a legal case against the SEC. Excuse me. And that's why lawyers in America are so wealthy, right? It's a game for the rich and the wealthy. So, you know, then we had the situation, right, that we thought, Mr. Deaton thought it was going to finish and expire and settle, you know, the whole SEC thing on the 31st, but it looks like it may take longer because, as Mr. Deaton said, March the 31st would be the earliest date based on the fact that there are numerous page documents for the court to scrutinize, something like 17 amicus briefings, which are friends of the court to Ripple. And, you know, this thing could go on, you know, for God knows. It's just all the lawyers making money and the SEC delaying even more. Seriously, absolute delay, right? So, you know, that's where we're at. We're probably going to be looking at, you know, the end of, I would say, you know, maybe March, early April. But, you know, we just have to wait, girls and guys. So I hope that is clear. It's very difficult to explain this because I'm not a lawyer. But that's my understanding of it. And I think the SEC are just not going to win this. I really believe that. They do not have the technical expertise. They don't understand cryptocurrency technology. They do not understand Ripplenet's technology. Ripplenet's technology is seriously, it's bigger than the internet, 1992-93. It is bigger than the internet. Ripple is the new tech company on the block. If they listed on the NASDAQ, what do you think they'd be worth? They'd be worth more than Google, Amazon, and I tell you, Apple together. Fair income, they're old technologies if they do not get into cryptocurrency technology. Okay, so look, thanks very much for listening. Please, I mentioned the other day on my podcast, my octopus teacher, a documentary from South Africa about a man having a relationship with an octopus. It was the most amazing story I've ever heard. I'm still obsessed with octopuses. That documentary, I saw it once and it's still stay with me. It's just incredible. So please have a look, open your mind up. I'm looking at all sorts of things. Octopuses at the moment, UFOs, the US government thinks there's really UFOs happening. We even found these amazing dinosaurs of some sort. In Australia, they found this intact dinosaur in Queensland and it was huge, like huge. You know, apparently the kangaroos used to be 8 foot tall and you know, goannas were like about 8 foot long, like amazing stuff. Anyway, guys and girls, that's enough of me. I'll talk to you very soon. Thank you.